Good afternoon, class. I will resume the online asynchronous learning method today, since most of you feel that recording is a better option for you. Nevertheless, I would still, fix a day in which we can discuss certain issues a short while, maybe something like 15 to 20 minutes after the afternoon class. So, again, for today, I'm not going to do that. So, we will continue on the topic of patents and trade secrets in cyberspace. In the last class, we stopped at the hot button issue in relation to cyberspace, specifically in relation to business method patents, or patents which are issued for doing online business. Okay. Now, so as you know, internet patents very important when it comes to doing online business, because the nature of online business is that you need lots of functions to be able to sell products or services online, and a range of services is necessary to entertain customers and take their orders and then ship their orders, and a whole range of services are involved in selling products online. And hence, if you look at the United States, they began to realize that e-commerce and e-businesses are going to be growing, and as such, doing business online is going to need business method patents. So this had generated a lot of interest, and you can see that in the United States, there has been a dramatic increase in the number of internet related applications or business method patents. And basically, lots of corporations, they want to have the edge in doing business online. And the best way to actually capture the market is to have efficient business method applications online. And therefore began another area of patents, right? That is business method patents, which are considered to include any process involving data processing, involving calculations, conversions, etc. Now, in addition to e-businesses, we also have e-banking. So you can see a lot of functions are required for banks as well in protecting their customers' financial interests. So again, you can see that the need for business method patents are growing leaps and bounds, right? And so hence the United States have already recognized it, and the US Patent and Trademark Office has also begun to process applications in this area. Okay, so now if you look at the business methods patents, it had begun somewhere in the 1995, and within 3 years, 1998, you can see the amount of applications and patents granted had actually grown. All right, in just this short 3 years time. Right now, one such patent, and the very famous one, is called priceline.com, and this is one of the first few patents that had been granted, okay, and to this internet retailer, right, who was one of the first on the scene. And basically this model is where the customers are going to name their price, all right, for actually ordering certain services, and if I'm not mistaken, it had got to do with some travel packages, right? And basically, customers will go and they will name their price, And then once they get the price that they've asked for, of course they'll be like, it's almost like an auction kind of style, huh? And then once the price that they have named, it gets accepted, then of course they get to get that package for themselves, right? So however, there are also risks associated with it because they're not sure the quality of the service, but nevertheless, this was one of the first business method patents that was granted online, right? The next came the sitesound.com. Again, this was another business method patent that covered selling music through digital downloads, right? And basically, anyone who downloaded the music, right, from sitesound.com, 1% royalty was demanded. And all right, and this includes the online music store CD Now, who is also selling music in the digital form online. Okay, so you can see here when these companies they come on the scene with these original business method patents, they get to have a monopoly over other businesses who come after them, right? And again, they have the edge over businesses that come after them because they tend to have a monopoly in that area. All right. So again, these are examples of business method patents. All right. And through the years, these type of patents have become very, very popular because of the fact that now online businesses are also growing, in such tremendous capacity. Okay. Now, if you look at this case, Amazon.com Incorporated versus Barnes and Noble.com Incorporated, here what happened was it's just a simple feature, right? Where this, I think we saw in one of the videos earlier. Basically, what Amazon had was this, like mouse click, where you just click on a feature online, and then the customer gets to straight away pay for the product that they're ordering. Okay, so they don't have to put it in the cart. It's just that straight away you can make the purchase click, right? So this was called the express lane feature, and this particular feature was patented by Amazon. All right. And then when the Barnes and Noble used a similar feature, Amazon had actually brought infringement action against Barnes and Noble. All right, at the court of first instant, that is the district court. The district court granted an injunction in favor of the plaintiff, which is Amazon.com, against the defendant. All right, but then the defendants appealed to the Court of Appeal, and interestingly enough, Amazon lost the round of case in the Court of Appeal, and basically it reversed the grant, meaning they took away the grant of the preliminary injunction in favor of Amazon. All right, but what they did was they said that they sent the case back to trial court and asked them to actually have a full trial to see the merits of the case. Okay, so that was the case of Amazon.com Incorporated versus Barnes and Nobles. But basically, what this case shows is that the Amazon was came up with this idea of this express lane feature. Although it's nothing that is fantastic about it, but it prevented other e-businesses from using similar features, right? Because the patent that Amazon.com had obtained was so wide, it was able to capture any other similar features brought by other e-businesses. So you can see how patent claims that are wide can prevent other competitors. It can even prevent innovation from taking place. All right. So this is a perfect example of that case. Now, if you look at this business method exception, right? Why I say business method? Normally, patents are not granted for methods, right? But because of e-commerce, right, this business method patents have become not no more an exception, right? Because it's now very what should I say, is very frequently granted by the United States Patent and Trademark Office. Right, now let's look at this case in State Street Bank versus Signature Finance company. All right, now what happened in this case was they had a data processing system for financial services. All right. So that was like this portfolio, single portfolio known as Hub. And they've got these different assets that go into the where people invest, and it goes into different spokes. You know what a spokes is, right? Like a cycle, you've got all the, like different, spokes on the cycle, right? On the bicycle, you can see those metal spokes. So you can see that you have assets, the hub is in the middle, right? And then it gets invested in different assets, right? And normally this particular system will determine the percentage share each spoke has in the hub, right? So there's kind of calculation in terms of how much is going to go from each spoke, and that is maintained in the hub, so that it involves some form of calculations. So it's basically a financial system which calculates, right, where all the different assets are invested in, and then it gets put in the hub, which is the center, right? Now, so this whole system, the issue arose in this case was this system patentable or not? All right. So the court decided yes, it was definitely patentable because it produced a useful, concrete, tangible result. And that's what the Patents Act function is, to see that there's some invention that is useful, right? Concrete, tangible, right? And therefore definitely, yeah, it was patentable, right? So you can see how slowly, in the beginning, these business methods were not patentable, but slowly the patent system began to absorb these kind of creative inventions and have, allowed patents for such business methods, especially in the context of cyberspace. It has become very, very relevant, right? So therefore, patent has also been allowed for these kind of, business method, inventions. Right now, next one. This particular video talks about the problems with patents and how to fix it. All right. Again, just to let you see, instead of encouraging innovation, basically you have a system that is being abused by big multinational companies. All right. And at the end, who is actually bearing the cost of it? It is going to be the very public that is supposed to benefit from it. Okay, so I'll just put this video for you just so that you can have an idea on the complexity of the problem with patents.
This video is sponsored by Brilliant. The first 200 to use the link in the description get 20% off their annual premium subscription. Imagine the perfect cattle grazing pasture. Blue skies, green grass shared by everyone. Of course, it can still only support so many cows. If the farmers were smart, they'd figure out how many and divide that among them. But that's a big if, because the incentives are all wrong. More likely, everyone would act in their own best interest, bringing more and more cows until they destroyed the land, and no one could use it. This is the tragedy of the commons. When resources are shared but limited, people will act selfishly and ruin it for everyone. It happens in public parks, traffic, and fishing. But sometimes the opposite happens. And that's the story of patents. Instead of land, it's ideas. And the problem is not that everything is shared, it's that nothing is. Big companies claim everything they lay their eyes on. They patent the process of making decisions, rounding rectangles, even, if you can believe it, filing patents. You name it, someone technically owns it. Maybe you don't plan on using it, but at least you can stop your competitors. And what's a few $1,000s in filing fees to a company making 265 billion a year? But all this ownership leaves little room for innovation. Just imagine how hard it would be to design a new smartphone today without violating anyone's patents. Good luck. Even if you could somehow figure out which ones you needed to license, which is already a stretch, it would simply be far too expensive. We think of invention as a sudden flash of inspiration, but usually big ideas are just one improvement on the last, or some new combination. Smartphones, for example, are a bunch of different ideas put together. And I mean a bunch. Google's chief legal officer says they might be susceptible to as many as 250,000 patent claims. That's a mess. All of this means that patents can be not just ineffective, but actually counterproductive. So, what's the solution? How can we encourage innovation in a way that, actually works? There are two ways to look at patents. First, as a right. Creating things takes time and effort. If you paint a picture or write a story, it belongs to you. So why should inventions be any different? Physically or otherwise, no one wants to be stolen from. This is why we use the term intellectual property. It's no different than a house or a car, which I'd argue is kind of true. A patent can be bought, sold, licensed, or abandoned. But if ideas are simply property, the inventor of a life saving drug could just decide not to share it. And if companies deserve monopolies over their creations, we're stuck with the system we have. Sure, in theory, we could adjust it, shorten the length of patents from 20 to 10 or 5 or even 2 years, ban patent trolls, or be more selective about which patents are approved. All of these would be a huge help, but they wouldn't solve the fundamental problem. To do that, we need to view them not as a right, but a trade. You and I promise to give companies a temporary monopoly, and they invest the time and money to make the products we want. But we're being ripped off. We're often giving a monopoly when a company would have made their product anyway. In other words, we're trading a lot for really nothing in return. Would Apple stop making iPhones if they couldn't file patents? They might make less money, but they'd almost certainly still be profitable. Even with copycats, they could stand out with things like better engineering talent and marketing. How do we know this? Because it's already true. Xiaomi makes every attempt to replicate products like the iPhone, but I'd say Apple is still doing okay. Or look at Lego, whose patents expired in 2011 but still makes billions of dollars. If anything, losing them made the company more innovative by giving it better competition. Of course, this isn't always true. A pharmaceutical company, for example, may truly need patents to protect its investment, but the goal is to give them just enough incentive and not a dollar more. And that exact amount varies by industry, which brings us to the wonderful world of software patents. From the outside, you may not think it's any different. An invention is an invention, whether it's made of gears or ones and zeros. But you'd be wrong. With software, the problems are 10 times worse. They account for 75% of all troll lawsuits and are twice as likely to be litigated. Here's the difference. A physical invention can easily be described as its parts. A ballpoint pen, for example, can be patented as a tube, an ink reservoir, and a rotating ball. But a digital one, of course, is made of code. And because there are many ways to program the same function, it wouldn't make sense to patent specific lines of code. Someone could just slightly change it. And besides, that's already protected by copyright. So instead, software patents usually describe less a process or method and more an idea or function. That's the difference between patenting toy bricks which stack using cylindrical grooves and the idea of connecting two objects. The latter sounds ridiculous. No one should own such a basic concept, but it happens all the time in software. The other difference is that, unlike, say, pharmaceuticals, software development is dirt cheap. Because nothing is manufactured, there's no limit to its scale. When Instagram was bought by Facebook for $1 billion, it employed only 13 people. and WhatsApp had 55 when it was bought for 20 billion. What matters is speed. A brand new software startup can beat the biggest companies on the planet if it moves fast enough, which means by the time a patent is granted, it may no longer be relevant. Compare this with government, whose strength is being slow and methodical, and you can see why it doesn't mix so well with tech. So, if patents are really a trade and different industries require different incentives, it only makes sense to negotiate individually. Why should the inventor of a buy now button be granted just as long a monopoly as the creator of a drug that took years and years of research? The solution is a prize system where the first inventor gets a check, not a monopoly. This way, companies compete, lower prices, and make their products more accessible. Not in 20 years when their patent expires, but today. Many new companies would finally have a fighting chance. And as a nice cherry on top, patent trolls would be eliminated overnight. Of course, there are some challenges. We need a system for determining what kind of inventions require a prize, and that money would have to come from somewhere, which probably means your favorite higher taxes. Again, it's not perfect, but it need only be 1% better than what we have, and that's already a pretty low bar. So, if such a simple solution exists, why aren't we using it? For one, because the companies that benefit most from patents are the ones with money to lobby for them, and because many people just don't know much about economics. There just isn't much awareness. But patents and the stock market are really economic games. And with today's sponsor, Brilliant, you can learn the hidden mathematical rules to better understand them. It teaches concepts like game theory, economic statistics, and tons of other topics on science, math, and computer science. Unlike your professor, Brilliant understands that people learn by doing, not just memorizing over and over again. So you'll solve riddles, play with graphs, and answer challenges as you progress through the lesson.
All right. So, okay, as you can see, right? Um, we don't understand, right? That we got to get you to do things as opposed to just, memorize things, right? But unfortunately, our system here, we encourage you to memorize, right? Okay. Anyway, so coming back to this, I hope you can see the whole complexity of the patent system. All right, granting patents for products such as pharmaceuticals, and then you have a monopoly over 20 years. And for software systems, of course, it doesn't make sense, right? So it's like a one system that fits all types of inventions when it shouldn't be so. And today, the way the companies are, using the system is to the detriment of the public. All right, so that is why it is very important for us to understand this. And basically, it's the small companies that are going to lose out, right? So that's basically the reason why the patent system has got such bad reputation.
To get
All right.
started or dive
Sorry, guys. Huh?
off
Okay.
their annual premium subscription. Ima-
Okay, sorry about the glitch there. All right, so now we look at possibly with more awareness, right? How this particular system, because the public generally have got very little understanding about the intellectual property system, so it is being utilized by the big companies who knows a lot about the economics of it, and they know how to manipulate the system uh, in which the public ends in the losing game. All right, so that's why I think awareness is very important. Anyway, coming back to the story of patents, right? The international protection of patents is covered by a few international treaties, such as the Paris Convention for the Protection of Industrial Property. Okay, this is the first major convention for protection of industrial property. You can see was implemented in 1883. And then of course the most I would say uh, the one that is highly controversial is what you call the agreement on trade related aspects of intellectual property rights. Now, this particular international agreement is very much, should I say, problematic for developing countries, because this agreement was basically forced on to the developing countries by the developed countries, such as the United States, Japan, and a few other, industrialized countries. Uh, these countries, the industrial countries, believe that the developing countries like to, copy their inventions, and therefore, what they do is they have brought this agreement to force all developing countries to, sign on to these international convention, and make sure that they have got national legislation that incorporate the provisions of these international conventions. Then you have all these zone agreements like North American Free Trade Agreement and so on and so forth. So all of these basically, they try to use trade as a method in which they enter into agreements through trade, and they require the countries who want to do trade with these industrial countries to ensure that they have some form of intellectual property laws in their countries. Okay, now, okay, so if there's patents are not preferable, then what alternative does a business have? I think you saw it in the last week's video. If you do not want to actually, protect your invention through patents, then you have an alternative, which is a very old system. It's called the confidential information. All right. So that means basically you just do not let very many people know about your secret. Right. That's confidential information. Now, of course, as you know, human beings, they're not very good at keeping secrets. So the way you keep your secret, it has to be only, divulged to people whom you trust. All right. Now, will that work in the context of businesses? Right. Obviously, it works, because if you look at Coca-Cola, right, and like Kentucky Fried Chicken and so on, right? Colonel Sanders' recipe and all that. Now, these basically, they have thrived through the years, without really letting anybody in on how you make the drink Coca-Cola, right? That's still a secret. It's still under confidential information. And the advantage of confidential information is there is no time period limitation for it. For example, patents, you are given a monopoly for 20 years, right? But after 20 years, it goes into the public domain. But with confidential information, that doesn't really happen, because so long as the information is kept a secret, you have the edge over any other businesses. But with patents, once it goes into the public domain, others can actually, use that particular, information to their benefit. All right. So again, it's a matter of deciding, which your business, do you want to keep that particular uh, innovation a secret, or would you want to actually go the patent route? Okay. So again, if you look at secrets, generally there could be a personal nature, it could be a commercial industrial nature, or it could be something that's to do with national security, right? So secrets could be, of all types, right? Now, but we are going to focus on trade secrets, all right? Trade secrets, when it comes to trade secrets, we call it confidential information of commercial nature. And this particular concept had evolved in common law, right? Basically, when businesses are, they hire employees, and then employees have access to some of the business, secrets, etc., right? And sometimes the employees, when they leave that company and go to another company, they may actually divulge that information. So, so under common law, they recognize this potential problem, and they came up with this, this particular area of law called confidential information, right? And so basically, you have to look to see which type of information is considered to be a trade secret. To know whether something is a trade secret or not, you cannot, it doesn't have like the same specific kind of feature for every business. For every business, different types of information will be considered as a trade secret. So you have to look at the surrounding circumstances to know which information is a trade secret. Okay. Now, if you look at patents versus trade secrets, for patents, the invention or process has to be novel, useful, or non-obvious. Or in the case of Malaysia, we use the word novel, non-obvious, and has industrial application. All right. And of course, the period of protection is 20 years. But however, if you look at trade secret, there is you're not going to rely on a system to protect your secret. You have to take the responsibility to protect that secret, because remember, trade secret has an impact on your business, because so long as it is a secret, your business will thrive, right? So there's no time limit to its protection because you are protecting it, right? And so therefore you can protect it for as long as you want to keep it a secret, right? So that's the difference between patents and trade secrets. Okay, you can see there are pluses and minuses for both, but basically, in the context of trade secret, you are in control. In the context of the patent system, you give the control over to the governmental authority. All right. And I think it is relatively more expensive to maintain a patent than a trade secret. Right now, so if you look at protection of trade secrets, companies engage in lots of R&D, so that they can have a competitive edge in the marketplace. Right. And so they try to find ways to keep or retain that competitive edge. Right. So therefore, they have to actually devise particular systems to ensure that their trade secrets are zealously guarded, so that other industries will not try to take away whatever edge that they have from their trade secrets. Okay, so when you talk about trade secrets, they can consist of processes, formulas, secretive data, anything, sometimes even a list of clients, right? All of these things can be your trade secrets, right? So it's very important for us to protect this kind of information and only give very few people access to them so that they can remain as trade secrets. Now, if you look at Coca-Cola, apparently the company, right? They've got the CEO and the deputy CEO. They do not even fly in the same flight, because in case the plane crashes, then the secret trade secret for the formula of the Coca-Cola would not be there anymore. So can you imagine to what lengths sometimes some of these companies go to actually protect their trade secrets? Okay, now, so if you look at the disadvantage with patent protection, it's limited period, all right? For you to be granted a patent, you have to actually, give whatever information about that invention, all right? So that means that it cannot be a secret anymore, right? Because you have to reveal all the steps involved in creating that particular invention or innovation, all right? So that's the disadvantage of patent protection, right? And the advantage of trade secrets is that no registration is required, right? And therefore, you don't have to disclose any information, right? Beyond a select few persons that you trust in your business. Okay, so in Malaysia, trade secrets and confidential information are also based on common law. So you see the word common law, basically it means that law that's been developed from decisions of courts. All right. So the trade secret and confidential information is consists of principles that are derived from court cases. All right. So there is no specific statute or act that actually regulates trade secrets and confidential information, right? um, and therefore you can see that it is actually just case law basis. Now, if you look at the United States, however, trade secrets are protected by a statute. That means they've got a legislation that specifically protects the trade secrets. All right, so they call it the Uniform Trade Secrets Act, which defines trade secrets as information including a formula, pattern, compilation, program, device, method, technique, or process that has independent economic value. All right. And is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So sometimes a list of clients that you have, that also has got economic value. All right. So can you see the whole range of information that could come under trade secrets, from formulas to a list of clients, right? So it's a wide range. Right. Now, so what is the requirements, all right, to succeed in protecting your confidential information, right? These are the following elements, all right, for confidential information. They use an objective test, all right? First, the information must be such the owner believes that it'll be injurious to him or it will be advantage to his rivals. So either if that information is leaked, it will damage him, injurious to him, or if that information goes onto the hands of his competitors, they will have an advantage. All right. So that's the first criteria, right? Whether the owner is the first owner of that information, believes that that information, if it is leaked, it will be injurious to him or advantageous to his competitors. Second, the owner believes that it is confidential, right, or is a secret, and it is not in the public domain, right? Okay, so these are the first two ones. One, it is going to be, if it's leaked, it's going to be injurious to him or advantageous to his competitors. Second, the owner believes that it is confidential. And then third, the belief number one and number two must be reasonable. And finally, the information must be used in the light of usage and practices of a particular trade or industry. So that means that information must be seen in the context of a particular industry. So if you take the example of Coca-Cola, it will be looked in the context of the beverage industry, right? So this is the elements that was decided in Coco versus Clark, right? It's a common law case. What are the elements to establish liability for breach of confidential information, right? So it's very important that when this information is given, let's just say to another person, that person knows that that information is being given to him in confidence, right, or with the obligation of confidence. So, for example, if you have got employees that you trust, when you actually give this information to them, they know that this information has to be safeguarded because it's very important that that information remains confidential or secret, right? So that means the recipient of the information must know that, right? And therefore, if there has been an unauthorized use, okay, then it could actually be of detriment or prejudice to the owner, right? So these are all the elements that are very important based on the decision in the case Coco versus Clark, right? Now, so what's the objective test, right? So remember, in law, there are two types of tests the court will use. One is to use the objective test, right? And the other is to use the subjective test. Now, what's a subjective test? Let me start explaining what's a subjective test. If I ask you how you feel, now that's subjective, right? However, if I use an objective test, I will ask, now what would a reasonable person feel in that situation? All right. Now that's an objective test. But subjective test is asking you how you feel in that situation. All right. So in the context of confidential information, the court, normally use the objective test to see whether a reasonable person who receives that information will know that the information given to him is in confidence, and therefore it imposes on him this obligation to keep it as confidential. All right, so that's the objective test. Would a reasonable person know that this information was given to him in confidence, and therefore he has to safeguard it? All right, so that's the objective test, right? Now, here, this particular video, I would like you all to go ahead and look at it on your own. All right, so I've uploaded the slides, right? So you can basically look at patents in cyber age, and I think that will give you a good idea on the what do you call it, the problems faced by businesses, all right, in the context of a cyber age. All right, and you can sort of actually have a listen to this particular video, and then perhaps you can actually use it in your project as well, your group project, especially those who are doing on intellectual property. You can actually see what are the current issues, right? Okay, so that is in the context of this particular video. All right, and here okay, so the good thing about this trade secrets is that even though, let's just say, a person reveals the trade secret, it does not necessarily destroy the element of secrecy, right? Because if you look at it, if, say, for example, an employee, right, sort of takes that information and either uses it himself, right, it doesn't mean that that information is no more a trade secret. All right, and whoever who steals that information or uses it without authorization, right, to the detriment of the owner of that information, right, that person can be, sued for the tort of misappropriation. What's the meaning of misappropriation? Basically, misappropriation meaning stealing, all right? But they use the word appropriate. Misappropriate means wrongfully taking away, all right? So if a person takes away your business secrets, and especially your employees, your ex-employees, you can actually sue them for the tort of misappropriation because they have either wrongfully obtained or utilized the trade secret. So either these employees, ex-employees, they could use it for themselves, all right, or they can take your trade secret and give it to somebody else for a price, all right. So either way, both parties can be sued for that purpose. Okay. Now, so it becomes very important when you set up a company and for you to safeguard whatever business secrets that you have, especially because, if you look at trade secrets, normally it's the senior executives of the company who usually have access to these trade secrets. But because they are at the top of the company, they are actually going to be attracted to other companies who are going to hire them so that they may have information about the inside operations of a particular company. All right. So actually, it is very important that when you hire these senior executives and then they have access to trade secrets, you will find that they are the ones who are going to be hired by your competitors, and then the competitors may hire them so that they have got information about the inside dealings of your company, right? So therefore it's very important that you have employment contracts with clauses in the contracts that actually indicate that they are going to be liable if they actually reveal such secrets, right? Okay, so the only course of action for previous employers is to actually bring action to prevent such disclosure of trade secrets or confidential information. Okay, now, if you look at Earthweb Incorporated, all right, this case, all right, a senior employee was in possession of a number of trade secrets, left his position in the company in an allied field. The former employer, Earthweb, sued to prevent him from being employed with International Data Group and to prevent him from disclosing trade secrets acquired from Earthweb. All right, so what did the employer do? Former employer, he sought preliminary injunction to prevent this employee from commencing employment. All right. So, what was the issues in this case? Okay, whether Earthweb had established that it would be harmed by the disclosure of its trade secrets. Second, whether the employee had breached the non-compete agreement with Earthweb. What's a non-compete agreement? Basically, is like if you are hired by another company in the same business, will not use the information or use the information for competition purposes. All right, so that's the two issues arising, and the second issue is whether this employee had breached that agreement or not, right? So in this case, what happened was the plaintiff, Earthweb, they lost the preliminary injunction, application for preliminary injunction. Injunction is actually preventing the employee from actually using a particular, information. So no, sorry, in this case, the injunction was to prevent this Schlack from starting employment with data group, international data group. So they could not get the injunction because the plaintiff could not prove that there is going to be irreparable harm if Schlack works for international data group, right? So they felt that this non-compete agreement was too broad, and so as to even prevent somebody from working, right, with people in similar industry, and therefore the court refused to give the injunction and said that that agreement was unenforceable, right? So you can see to what lengths sometimes businesses go to sometimes even prevent employees from working with competition, all right? Just so that their secrets will not be divulged to the competitor. All right, so you can see trade secrets versus restraint of trade. I think you all have studied the Contracts Act, and you remember under the Section 28 of Contracts Act, there's a clause called the restraint of trade clause, and the case was Wigglesworth versus Wilson Anthony. I don't know if you all remember the case, but basically it says that any clause in the employment agreement that is too broad is going to be void, right? So basically, to prevent that, you just include a clause of confidentiality, right? Okay, so that is in terms of protecting your trade information. So ultimately, you will find that you have to do a balancing between the interests of the employer in protecting his information, trade secrets, and the freedom of the employee to look for employment elsewhere so that he can promote his expertise. All right. So this is basically the balancing of interest that has to be done by the law, right? So again, so when you talk about protecting confidential information, it is about protecting the know-how. And when you protect copyrights and patents, it is about information related to show how. Right? Can you see know how? And the other is show how. Show how to make an invention. All right. As opposed to know how to do something. All right. The other one is show, because normally when you talk about patent, is about showing how to do the invention. Right. So here, when you talk about technical information, confidence cannot play a long-term role, all right, unless, of course, it is put to commercial use, right? Now, if you look at a mechanical device, it will always reveal its workings once it's marketed. So, for example, if you market the iPhone, people can take it apart and see how it works. That's called reverse engineering, right? So, once you market a product, basically, anyone who has got the kind of expertise in that area, they can take apart that invention and see how it works. All right, but a process of manufacture cannot be detectable. Right, somehow it's more difficult to see a process how it works as opposed to a product. All right, so therefore you can see, right, protection of patent is only for a limited period of time, right? And if you keep an invention secret through confidential information, all right, you do not need an additional form of protection, all right, and it's not tied to a specified period of time, right? And anyone who receives that information, such as third party, who acts in breach of confidence and who is proposing to use it, can be restrained through an injunction, all right? Especially if he knows that that information is confidential. Especially if you're a competitor, you will know that that information that you are acquiring from, say, a former employee is confidential, right? So that person has a recourse by bringing a legal action, and through an injunction can stop that person from using that what do you call information, right? So now, what are the remedies that's available, right, when somebody infringes your rights? All right, one is injunction. You know what an injunction is, isn't it? It's a court order that prevents a person from doing something with your information, or from doing something with your invention. All right, so the remedies available is injunction, which is a court order that prevents the other person from continuing with the infringing act, right? Or using your confidential information. The next remedy, which all of you have already studied in the context of contract law, is damages. All right, damages basically means that you are going to claim for any kind of loss that your business have sustained as a result of the infringing act. All right, and the third is an account of profits. So, for example, if say that person has taken that confidential information and made profits out of it, see, you can actually get an account from the competitor of the profits that they have accrued or have accumulated after using your invention or after using your confidential information. So that's another remedy, account of profits, right? And then finally, another remedy that you can apply to the court is order for destruction of articles. So if this person have used your invention and have manufactured, based on your, patented invention, you can require this person to destroy whatever, they have, manufactured as a result of your patent. All right, so you can order for the destruction of articles. So these are the remedies available under this breach of your rights as either intellectual property owner or as the person who is the owner of the confidential information or trade secrets. All right, so with that, we finish this topic. All right, and I will put some questions for you to answer, and please do try them. And I will discuss with you in next class about your upcoming second test. All right, and with regards to your first test marks, I will actually give you that information by end of next week. Okay, thank you.